My name, as you have just heard, is Elise Edson. I am an associate in the International Arbitration Group at Shearman Sterling's Paris office. It is such a pleasure to be a part of this project and to introduce the four speakers on our first panel today: Professor Anna Petrig, Mr. Martin Doe, Professor Diane Desierto, and Mr. Eric Dewiki. They will be addressing how arbitration may be used and has been used to address human rights issues at sea as on land. I could spend a good part of the 1 hour allotted to the first panel simply introducing each one of them and summarising their achievements and appointments. Instead, I will limit myself to a very brief and highly selective introduction of each speaker before they begin their presentation. At the conclusion of the four presentations, there should be some additional time remaining for general discussion. So I do encourage you to make use of the Q&A function during the presentations to send through any questions you may have. Please do try to keep them brief and don't forget to mention your name and position so that I can properly attribute each question. We will hear first today from Professor Anna Petrig, Chair of International Law and Public Law at the University of Basel, Switzerland. Professor Petrig has worked in private practice, the courts, and the legal division of the International Committee of the Red Cross in Geneva. She has provided expert advice and legal counsel on maritime-related matters to the Swiss government, NGOs, and international organizations, notably on the registration of ships, the use of private security companies at sea, and the protection of underwater cultural heritage. Professor Petrig has sat as judge ad hoc for Switzerland before the International Tribunal for the Law of the Sea, and currently sits on the board of the Swiss Maritime Law Association. She writes widely on the law of the sea, as well as international human rights law, public international law, and criminal law, and is the co-founder and co-editor-in-chief of the Maritime Safety and Security Law Journal. Professor Petrig today is going to give us more of an overview of human rights issues as they arise at sea, the challenges of enforcing human rights standards at sea, and the potential for arbitration to provide victims with a means of redress. Professor Petrig, thank you very much for being with us this afternoon. Over to you.
Thank you very much for this kind introduction and for the invitation to present at this most interesting event. I will be talking about arbitration as a means of effective remedy for human rights abuses at sea. And when it comes to human rights at sea, I guess we have quite a progress as regards substantive human rights law. Back in 2008, France, for instance, still asserted that the Human Rights Convention, the European Convention on Human Rights, would not apply at sea because there is no maritime specific provision in that convention. However, after having been convicted by the Strasbourg Human Rights Court, they adopted a law in 2011, which is very much human rights based as regards policing the sea. So we have quite a progress as regards substantive human rights law. There is now high acceptance of the principle that human rights apply at sea as they do on land, as David Hammond mentioned at the beginning. However, there's still a bit of an uncertainty what the specific guarantees really mean when applied at sea. When it comes to deprivation of liberty, for instance, what does it mean to be brought promptly before a judge in the maritime setting? However, the real problem is implementation and enforcement of human rights, and Alex has already spoken about this. Enforcement and implementation is very weak. Mary Robinson at some point said about human rights, she spoke of a failure of implementation on a scale that shames us all. And she said that for a land-based context, but when it comes to the sea, it's even worse. Why is there an enforcement gap? Why is it so difficult to guarantee human rights at sea? And I will come back to some things which has been said by Alex. Well, the Earth is quite a watery place. More than 70% of its surface are covered with water. And we have only very limited resources to control the whole area. It's impossible to patrol, control, and monitor the entire sea. So the solution has been that you would subject ships to the control of the flag state, and that the flag state has the primary responsibility to ensure that activities at sea are safe, secure, and in accordance with the law. However, we have a problem with the flag state jurisdiction because we have many flags of convenience. So if you do business at land, you are subject to the jurisdiction of the place where you do business. At sea, it's a completely different world. You can more or less choose your flag, and with this, you choose your law and your court. So you have more or less complete freedom to which standard you want to subject yourself. And it's not surprising, given that there's a lot of pressure, financial pressure, etc., that many opt for so-called flags of convenience. They are quite popular. So flags which have quite low standards in terms of labor, environmental law, etc. I'm taking the example of Liberia. Liberia really ranks at the top when it comes to flag state importance. It has meanwhile overpassed the Marshall Islands, which are number 3, and Liberia is number 2 in terms of flag state. Number 1 is Panama. But when it comes to the rule of law, there are various indexes established by NGOs. Liberia really ranks at the bottom of the league. Like, I looked it up for last year. There's an important rule of law index, and as regards regulatory enforcement, like the willingness and ability to enforce the law, to subject facts occurring within the jurisdiction to the law, it ranked very low. It was state number 102 out of 120 states analyzed. So one of the most important flag states has a very low rule of law index. So you see this gap which is resulting. So the public court system does not really work because we have this problem of flags of convenience, and therefore it's very important to supplement it by some sort of private justice system. Of course, in an ideal world, you will rely on the public system, but we are unfortunately not living in an ideal world when it comes to human rights at sea. And such private justice system could be arbitration. Cronstedt, Aisberts, and Thompson's in a paper defined arbitration as a judicial system without a country. So since the country systems are not working in our case, arbitration provides us with a means to take it away from the domestic systems. So what constellations could be subjected to arbitration? Who are the potential users of the system? David and Alex already emphasized that it's a victim-centered approach. So the most obvious constellation is that individuals, victims, direct victims of human rights abuses would, for instance, make a claim against a business entity. However, it's also conceivable that, similar to some human rights judicial bodies where NGOs or unions can file a complaint on behalf of victims, that you could also have NGOs or unions formulating a claim against the business entity. For instance, because of poor labor conditions. You see here a brochure on so-called sweat ships. What is it really like to work on board cruise ships? And you also see the logo of ITF, an important union in the shipping realm. However, it's also conceivable that a business entity is victim of a human rights abuse and it would formulate a claim against another business entity. It has, for instance, become very prevalent that merchant ships rely on private contractors in order to ensure security on board, and it could be that one of these contractors does not behave in a way which is in line with human rights. Another constellation is that an individual would allege that a state has violated its human rights, or even an international organization. Here you see a picture of piracy suspects which have been intercepted and later arrested by Danish forces. You can see the Danish flag on the boat. And they have not been brought before a judge. They spent more than 40 days on board a Danish vessel without seeing a judge, something which would never occur on Danish mainland. So they could, for instance, formulate a claim against Denmark, but often such enforcement mission takes place within a multinational operation. So it's also conceivable that an individual would, for instance, formulate a claim against the European Union or NATO or any other international organization involved in enforcement activities at sea. Yet another constellation would be that the coastal state would formulate a claim against the business entity. This is maybe not directly victim-centered, but if we take the example of Indonesia, Indonesia established a system where they condition the granting of fisheries licenses to fish in their exclusive economic zone upon compliance with certain human rights standards. So if that business entity does not comply with the conditions formulated in order to grant the license, they could subject such a dispute to arbitration. Yet another constellation could be that a flag state addresses a claim vis-à-vis a coastal state. In the law of the sea, you have the principle that the flag state can exercise a quasi-diplomatic protection on behalf of all which are involved in the operation of a ship. So the crew, and it doesn't matter of what nationality the crew members are, it can even exercise diplomatic protection for all others involved in the operation of the ship. So the ship is perceived as a unit and the flag state can act on behalf of them. So it's conceivable that a flag state, a responsible flag state, formulates a claim, for instance, against a coastal state, which arrests a ship and mistreats seafarers, or where deprivation of liberty is not in line with human rights. So you can see that we have many different possible constellations which could be subjected to arbitration, and this triggers the question, what procedure would be appropriate for human rights at sea arbitration cases? And I guess it very much depends on the user. We have seen there are so many different constellations, and in some constellations it's quite obvious that there is an imbalance of power between those formulating a claim and the addressees of the claim. And I guess we would have to have almost different procedure for different constellations and rules which take these difference in terms of balance of power, etc., into account. Well, what approach could we choose for human rights at sea arbitration? I guess an institutionalized system has some benefits. Of course, to pursue a system of ad hoc arbitration without any institutionalization, it's a low-key approach, but it has its downsides. On the other end of the spectrum, we would have an institutionalized an institution, a treaty approach similar to what we have for ICSID, the investor-state arbitration. However, at this juncture, it's difficult to imagine that states would adopt a multilateral treaty. I guess there's a certain treaty fatigue, so I guess that's not a very viable option. But something in between these extremes, an institutionalized system, but based on a soft law approach, I guess there are many benefits to such an approach. Some advantages are mentioned in the white paper. I will not mention them again, but I will maybe add two aspects. One is the visibility. It's much easier to make an institution visible than something which is ad hoc and which changes all the time. And an institution has also what we refer to as an institutional memory. So we have an institution which can collect and publish cases and which can also contribute to building up kind of a corpus of case law relating to the application of human rights at sea specifically. So what are the benefits of arbitration in the field of human rights at sea? Of course, there is the remedy aspect. That's arguably the most important aspect. However, there is also a preventive aspect. If we, for instance, integrate arbitration clauses in contracts, the respective business entity will start managing human rights risk. It has a preventive effect. And I guess these two benefits combined, the remedy and prevention aspect, results in the refinement, development, and stabilization of the human rights at sea regime. If we have a lot of cases, we have a sort of case law, a corpus of case law, so we will better understand what human rights really mean when applied at sea. And also prevention means that there is a lot of discussion and engagement on what must be ensured in order to guarantee human rights on board ships. So this will also contribute to building up a corpus of human rights law specifically for the maritime context. And even if we put the benefits in a broader context, and Alex has already mentioned that a notion, the rule of law, I guess arbitration would really strengthen the rule of law at sea. I will end with a quote. "The history of the rule of law is a tale of kings and judges, of revolutions and bills of rights." However, I would reply that it's a tale which plays on dry land. It's a concept which suffers from sea blindness, but I'm quite confident that it also applies in the maritime context. And I guess arbitration would be a step towards a stronger rule of law at sea. Well, on that note, I would like to thank you for your attention, and I look forward to the other presentations and to your questions.
Thank you very much, Professor Petrig, for that extremely insightful overview of human rights issues as they arise at sea and how arbitration can perhaps be used to fill the enforcement gap when it comes to remedying human rights violations. Our next speaker will be addressing how arbitration has in fact already begun to play that role. I am very pleased to next introduce Martin Doe, Senior Legal Counsel at the Permanent Court of Arbitration in The Hague. At the PCA, Martin works closely with arbitral tribunals to resolve disputes involving various combinations of states, state entities, intergovernmental organisations and private parties. Martin also assists the PCA Secretary General in carrying out his functions under the arbitration rules of the United Nations Commission for International Trade Law, UNCITRAL, and regularly assists in the diplomatic work of the PCA with its member states and other intergovernmental organisations. He was an active member of the drafting team for the Hague Rules on Business and Human Rights Arbitration, which were launched just in December last year. Martin, thank you very much for joining us. Without any further ado, you have the floor.
Thank you very much, Elise, and thank you very much for the opportunity to participate in this extremely interesting event. So without further ado, I'm going to start getting into more the procedural aspect and really what arbitration can do to help, and particularly by exploring where we've already seen some of these developments in a rather similar, if not identical, context, dealing with disputes that are already arising in the context of human rights. And in order to do that, I wish to allude to some of the advantages of international arbitration that are also highlighted in the white paper. Here are four of the ones that are highlighted there, some of the classical ones: neutrality, the ability to bring in decision makers with expertise who will render final and binding decisions in accordance with law. And finally, a general flexibility and autonomy of the procedure which can be designed and adopted within an arbitration context. And just on the left of this particular slide, you see something I'd like to emphasize, which is that I come from an organization that really started with public law disputes as those that were treated in international arbitration. That is the CSS Alabama of the Alabama arbitrations at the end of the 19th century, which gave rise to modern arbitral procedure, which was codified in the bottom left corner in the 1899 Hague Convention, and arbitration still features as one of the principal means of peaceful dispute settlement in Article 33 of the Charter of the United Nations. And on the flip side, we have the challenge that Anna has identified, which is really also faced in the business and human rights context, which is we have some progress with states upholding their own direct duties. We have some progress with business and other stakeholders upholding their duties. But then we really have a quite serious deficiency in what is the third pillar of the UN guiding principles on human rights, which is access to remedy. How do we actually turn some of these commitments that various stakeholders are making into actual remedies that can be taken advantage of? And here in the 2011 UN Guiding Principles on Business and Human Rights, and in particular Principle 31, defined actually some of the criteria that we should be aspiring for what are non-state judicial grievance remedies. And here they are. So the real challenge that we have for trying to bring arbitration into a human rights space is to try and marry those advantages of arbitration with these criteria to measure the effectiveness of remedy. And thankfully, it was not too long after the UN guiding principles came into being in 2011 that these already had the chance to be put into practice. Sadly, it was due to a rather unfortunate event, the Rana Plaza disaster, the collapse of that garment factory in Dhaka, Bangladesh, which claimed the lives of over 1,100 garment workers who were working in that building, but gave rise to new impetus to say this is exactly the sort of thing that should not happen. And in that context, certain global and local unions negotiated with global brands that were taking advantage of garment workers in Bangladesh in order to conclude an accord on fire and building safety in Bangladesh, which included not only legally binding commitments, but also arbitration as the backstop in order to address that enforcement gap. And it was not too long after the Bangladesh Accord actually was concluded that this particular instrument was actually put into practice, not just in theory, but in practice there. 2 arbitrations were actually commenced under the auspices of the Permanent Court of Arbitration in 2016 for the alleged failure to actually uphold the commitments that were made in the Bangladesh Accord. And these cases began under the UNCITRAL arbitration rules, the rules that were just mentioned by Elise. But the particular context of arbitration of disputes involving human rights came to the fore quite quickly. You can see right here a quote from the tribunal saying, "This is not your typical public law arbitration. This is not a traditional commercial arbitration. It's not even a typical labor dispute." And so the tribunal had certain challenges that it had to navigate in trying to adapt the particular procedure to this highly specific context. For example, the tribunal grappled early on with the transparency regime, transparency and confidentiality that it should apply. It noted that there was a public interest in this particular dispute. In fact, quite a number of stakeholders that should be kept abreast of what was happening within the proceedings, but also privacy and reputational considerations that formed part of the heart of the bargain of the Bangladesh Accord itself, and indeed the practice that had already arisen early on under that instrument. And the tribunal did an admirable job of breaking new ground, not least because of the rather esteemed individuals that were conscripted into serving on this tribunal. But the tribunal nevertheless ran into some constraints that were imposed by the UNCITRAL arbitration rules, which were, of course, not conceived to be used in this particular context. As you can see here, there were some constraints on holding private hearings and the non-publication of the award of the tribunal, which were imposed by the UNCITRAL rules, even though it's questionable whether or not the tribunal would have made that choice had it been left to its discretion. So in 2018, led by a working group that was already studying the possibilities for arbitration in the business and human rights context, you had a drafting team that was put together specifically to try and adapt the UNCITRAL rules to tailor them to achieve the objectives of arbitration in the human rights space. And this, once again, requires trying to marry or leverage these advantages of arbitration in order to serve the criteria for effectiveness of remedy of human rights remedies. So taking some of those, accessibility and equitability, for example, the tribunal might, in this space, as exemplified in Article 5 of what was adopted in the Hague Rules, might need to be more proactive and vigilant instead of just relying upon the theory of equal access and equality of arms in order to actually assure that accessibility and equitability. This is in many ways an expression of the neutrality of arbitration. The tribunal needs to, in fact, make sure that it is not used as a tool for human rights abuses itself. Legitimacy and predictability as well. The tribunal should be composed of persons of unimpeachable character and credentials if legitimacy is to be achieved within this particular space. This, of course, is an expression of that expertise that is sought to be leveraged in international arbitration. In respect of transparency, the default should be shifted towards openness in recognition of the public interest that is involved in disputes that involve human rights issues. Nevertheless, there need to be exceptions to take into account the reputation of potential respondents, but also the privacy and security of parties and witnesses and other participants in the proceedings. Indeed, there are even some kinds of disputes that do not require transparency, even though they may involve human rights issues. The Hague Rules were conceived to even encompass B2B, business-to-business disputes regarding adherence to business and human rights standards, such as in a supply chain, that may not actually raise the public interest or the interests of stakeholders and right holders in such a manner as requires that they be aired in open court. This, of course, is again demonstrating the flexibility to tailor transparency, confidentiality, privacy to the needs of the particular case. And finally, rights compatibility. In respect of rights compatibility, the drafting team recognized that the whole objective is to further access to remedy and further human rights, both in process and in outcomes. And the two are linked. So this led to an interesting requirement that found its way into the Hague Rules, which is the requirement that the tribunal shall state the reasons on which the award is based and shall satisfy itself that the award is human rights compatible. However, the commentary also clarifies that this is a requirement of procedure and form as part of the requirement of reasons and not of substance or applicable law. So this is not authorizing the tribunal to make a different decision than it would have otherwise, but rather encouraging the tribunal to think through the issues in the particular human rights context when it is rendering its award. This is actually promoting in a manner the enforceability of the decision. It is asking the tribunal to think about issues of public policy that might actually otherwise undermine the enforceability of an award that it might render. But as the thinking went along and more discussion was had as to adaptations of the UNCITRAL rules, the drafting team also began to come to the realization that a greater institutionalization was necessary in this space. As may be apparent in retrospect, robust human rights remedies require robust institutions. So for example, access depends in large part on costs. And in order to ensure this type of access, you may need an institution to make sure that the costs of the process itself do not create that barrier. In terms of legitimacy and predictability, it's no good to say that you want expert decision makers if you cannot actually ensure that such experts are actually appointed. The edifice of legitimacy of the arbitral mechanism depends upon it. And even more so, the measures necessary to ensure confidence in an arbitral system may change over time. So you actually need to delegate the ability to keep up with new challenges. And what good is publication and transparency if stakeholders in the public have no idea how or where to find the information about a given remedy mechanism? In fact, you need to try and centralize it and be a little bit more proactive in making information available if it is to reach that goal of continuous learning and progressive development. And finally, what good is it to vindicate rights at the very end of the process if they're trampled over throughout the process? So once again, you will need an institution at the ready to put into motion a system for emergency relief, if that system for emergency relief is actually to be effective. And with that, I will conclude and pass the floor back to Elise and to my colleague on the drafting team as well, Diane. Thank you.
Thank you very much, Martin, for that perspective, both from the perspective of the PCA as well as a member of the drafting committee of the Hague Rules. We are extremely fortunate to be hearing next from another member of the Hague Rules on Business and Human Rights Arbitration drafting team, as Martin has just mentioned, Professor Diane Desierto. Professor Desierto is tenured Associate Professor of Human Rights Law and Global Affairs at the University of Notre Dame, focusing on international law, human rights law, maritime security, and the Association of Southeast Asian Nations, ASEAN law. She is also Professor of International Law and Human Rights at the Philippines Judicial Academy of the Supreme Court of the Philippines, and ASEAN Law Visiting Professor for the University of the Philippines Graduate LLM Program. Professor Desierto is active as International Counsel on Philippines and Southeast Asia matters before the Permanent Court of Arbitration, the Human Rights Committee, the International Criminal Court, ASEAN, as well as before Philippine courts and regulatory agencies. She speaks and writes prolifically on topics of international law and human rights, with over 100 publications to her name, including at least 4 books. Professor Desierto, thank you for taking the time to be with us today. I understand that you will be comparing the Hague Rules option, which Martin has just described for us in some detail, with other existing redress mechanisms. You have the floor.
Thank you very much, Elise. And my thanks to Human Rights at Sea, as well as to Shearman and Sterling, for the opportunity to make this presentation, as well as to engage with the varied experts and audiences around the world on this extremely important issue. Martin has already laid the excellent foundation discussing the Hague Rules on Business and Human Rights Arbitration. My task today actually will be to focus from the lens and the perspective of human rights victims at sea as to the comparison of redress options that they may have, looking at arbitration vis-a-vis the limited options that are available, and why business and human rights arbitration may well be one of those remedies that could be opened for human rights victims at sea. So one of the first things, of course, that human rights at sea claimants will have to think about are certain factors when you're evaluating the choice of a remedy, particularly given, as discussed by Professor Petrig, the complexity of the maritime space, the diversity of actors that are involved, the overlapping jurisdictions that may be exercised, and the ongoing limits with respect to the exercise of enforcement at sea in a vast maritime space. As I said, this plays out differently, and has already been discussed, this plays out differently in different human rights violations, which can and will involve non-state and non-state actors, whether it is human trafficking, the treatment of refugees and migrants, labor violations in ships and vessels, as has been discussed earlier, on seafood slavery, the employment conditions in cruise lines, among others. It can also involve search and rescue of fishermen and mariners in distress. In my particular geographic area of involvement, which is Southeast Asia, this is quite robust with respect to the South China Sea, where in recent years, Filipino fishermen, as well as Vietnamese fishermen, have encountered many difficulties, especially involving collisions and abandonment at sea from the actions of both private as well as public vessels in the South China Sea. There are also massive marine environmental violations, which in the human rights space has already been seen as part of a nexus between human rights and environmental protection, as well as climate change. In this regard, I will recall the Inter-American Court of Human Rights' latest advisory opinion on marine environmental protection, definitely affirming as a matter of law that environmental protection and human rights protection are actually almost synonymous. So even in the examination of illegal wildlife trade, the destruction of coral reefs and natural habitats, the protection of artisanal or traditional cultural fishing rights and sustainability practices, there is a definite nexus. In my own work on economic, social, cultural rights, there is an even deeper nexus with environmental violations, because in this respect, when we talk, for example, of the Covenant on Economic, Social, Cultural Rights, we are looking at the nexus of the right to an adequate standard of living, the right to food security, the right to the highest attainable standard of physical and mental health, which all encompass environmental considerations quite readily. And lastly, as had been adverted to earlier, we can also be looking at human rights violations from states' own maritime law enforcement activities. And so there's a constellation, as rightly pointed out by Professor Petrig, of considerations in trying to examine what redress options there are. And we do have to take particular cognizance of the nature of the human rights violation and how to seek redress for that violation. There are also factors to consider with respect to the intersecting legal regimes that are inevitably involved when one tries to examine seeking redress for human rights victims at sea. As the subject matter, it is not only the corpus of international human rights law, which is already considerable, both from the treaty-based standpoint as well as from the customary international law standpoint, but also from the United Nations Convention on the Law of the Sea, the IMO conventions, including the Maritime Labor Convention, which, like the ILO, International Labor Organization conventions, look very specifically to labor standards, but from human rights law, particularly Article 6 and 7 of the Covenant on Economic, Social, Cultural Rights, human rights law may have far greater protections than may be present, say, in international maritime organization conventions, such as the Maritime Labor Convention or even the ILO Labor Convention. So we also have to recognize there may be some convergence as well as some divergence with respect to the scope of protection afforded to human rights victims. And again, there's also international environmental law, maritime law, the applicable regional or national law. We also have to contend with different assertions of sovereignty and regulatory authority in maritime zones, which, as discussed by Alex earlier, on the high seas, and even when we bring to bear global commons, such as the area, exclusive economic zones, contiguous zones, territorial seas and internal waters, and the nature by which coastal states, port states, flag states can exercise authority over these respective zones. That leads me to the third, on how to delineate between these jurisdictions and how to appreciate concurrent jurisdictions if you are a human rights claimant in these particular circumstances. The third as well is the classic evaluation that counsels for human rights victims have to consult with for victims themselves is the accessibility of the procedure. Is there a possibility for direct submission of an individual claim? Does it require state sponsorship, say under diplomatic protection, of a claim to a state or non-state actor? Will there be a possibility that an international organization or a civil society submission can be made on behalf of a group, class, or mass of claimants? Now, this differs across the board for human rights cases, whether they be transnational litigation, domestic litigation in coastal states, port states, or flag states, or resort to the UN treaty bodies, which are very specific, but also modeled on a very different paradigm of redress. It is not necessarily the same kind of reparative redress that we can, as I will discuss further, anticipate under the Hague Rules on Business and Human Rights. Fourthly, there would be also the corresponding evaluation of the evidentiary burden on human rights victims, especially in accessing any procedure. You have to examine what would be the fact-finding capabilities of a tribunal, especially given the asymmetries of power that Professor Petrig discussed in her presentation. Examine whether the procedure allows for presumptions, especially when the evidence of the human rights violation is actually in the control of the alleged human rights violator, and whether or not a presumption would exist under that procedure to accommodate the evidentiary burden on the human rights victim. The possibility for discovery procedures as well to ensure that human rights victims do have access to the kind of documentation necessary to substantiate their claim. And what role expert reports, say by the United Nations, by special rapporteur reports and other organizations, specialized organizations, can have with respect to the evaluation of a human rights process. we have seen in the recent case that has come up before the International Court of Justice that with respect to Myanmar, the Gambia versus Myanmar, that it's one of the first cases that extensively relies on fact-finding by UN agencies and by international governmental organizations. It was thus also a factor to consider if human rights victims will wholly share the burden of establishing the human rights violation to the satisfaction of the remedy of the tribunal from which they're seeking relief and remedy. And lastly, which is closer to my heart here, because at the University of Notre Dame, I'm the co-principal investigator of the Notre Dame Reparations Design and Compliance Lab. I'm very focused on taking a look at what reparative measures can actually realistically be available to human rights victims, especially when we take a look at the corpus of possible redress options, some of which are treaty-based, some of which are contract-determined, and some of which will actually depend on the default reparative rules of the jurisdiction that's asserting control over a dispute. In some instances, it may very well be the general law of international responsibility, which says our reparations may take the form of restitution, compensation, or satisfaction. It may be broader in some circumstances. It may be narrower in some circumstances, depending on, say, a coastal state's law determining relief for tort, contract, or criminal violations, or, as has already been discussed, what the flag state's rules are for regulating their own vessels flying the flag. So given those 5 factors to consider from the standpoint of a human rights claimant at sea, why should we take a look at some of the features of the Hague Rules on Business and Human Rights, which Martin has adverted to, which I will further elaborate as particularly unique to these sets of rules as opposed to other existing mechanisms, whether they be domestic litigation, transnational human rights litigation, or complaints procedures or communications procedures before the UN treaty bodies. Panel 2 will discuss this, so I won't discuss this in any deep length, but to the extent that the Hague Rules do already provide for the possibility of consent to arbitrate well in advance of any disputes to ensure stability between contracting parties, the Hague Rules Annex does have model clauses for pre-dispute submission to arbitration for contracts, as well as other agreements or instruments. It could also be negotiated to resolve existing disputes. And again, we have model clauses in the Hague Rules for this particular circumstance. The procedure itself, which is for me significantly important from the standpoint of human rights victims, the adaptation from UNCITRAL 2013 rules is to require that the tribunal provide a fair, efficient, culturally appropriate, and rights-compatible process to resolve the parties' dispute, including in particular by giving due regard to the urgency of addressing the alleged human rights impacts. Now, this is unique as opposed to any other set of arbitral rules. This provision does not exist as a matter of mandatory procedure, even for transnational litigation or for the limited communications procedures within human rights treaty bodies. There's considerable flexibility on the part of the arbitral tribunal to conduct the arbitration in such manner as it considers appropriate, but particularly giving due regard to the human rights impacts that are urgently at stake in this type of dispute settlement. And in this regard, the rules are also unique in that, and this is advantageous for human rights at sea claimants, if it is only monetary compensation that is sought, and it very well may be the case that the appointing authority determines it's more appropriate given the circumstances of the case, you can have an expedited arbitration where under a sole arbitrator proceeding, that is where the time limits will be halved, the proceeding is decided on the basis of written submissions without an oral hearing, and there's actually a more expeditious procedure to reach judgment. This may be appropriate in some cases where I can take the questions on Q&A in relation to this, especially for those who want to compare compensatory proceedings under the IMO, for example, vis-a-vis this kind of procedure. It's somewhat similar, but as I will discuss on the reparative aspect, the Hague Rules are much broader. Third-person submissions are also permitted in this proceeding, which is excellent for human rights organizations in that those who have a significant interest in the proceedings and can assist the tribunal in the determination of a factual or legal issue with a perspective, knowledge, expertise, or insight that is different from that of the parties, that is unique to that particular submission, could very well be of assistance and help the resolution of a dispute. And this has been important because, especially with respect to human rights claimants and the establishment of violations of specific treaties in the different intersecting legal regimes that I have pointed out to you earlier, it is quite important that there be this possibility that human rights claimants themselves may not be able to substantially produce directly before an arbitral tribunal. But because there is this opening, you can see an involvement of broader stakeholders who may be able to weigh in on crucial questions involving human rights violations at sea. And similar to the UNCITRAL rules, there is also a procedure for tribunal-appointed experts. Martin has already dealt with the issues of transparency. I'm not going to dwell on that. Section 4 is allocated to that and dedicated to that. All that I will say is that it has flexibility on the part of the tribunal to adapt to the needs of the parties to a business and human rights dispute. There are similarities to the UNCITRAL transparency rules, but the specific adaptations to business and human rights disputes looks at considerations of business or contractual confidentiality provisions as a possible compelling ground for non-disclosure. Again, that is subject to the determination of the arbitral tribunal. This brings me to what I think is the most important part of the Hague Rules, and that's probably just my own bias, but Article 45.2 of the Hague Rules provide for a reparative scope that is unheard of and is possibly the most expansive among all other human rights mechanisms that I have looked at, especially since I teach a class on human rights reparations at the University of Notre Dame. The award itself may order monetary compensation or non-monetary relief, including restitution, rehabilitation, satisfaction, specific performance, the provision of guarantees of non-repetition, and possibly recommendations for other measures that may assist in resolving the underlying dispute and prevent the future disputes or the repetition of harm, which shall be binding only if agreed by the parties. Now, this is significant because for quite a long time, even in domestic and transnational human rights litigation, the nature of reparations sought may not necessarily be customized or tailored to the individual needs of claimants. We have often relied on the categories of restitution, of compensation, or satisfaction, but if anything has been quite evident in the literature as well as in the advocacy for human rights victims, especially if you look at the jurisprudence, say, of the Inter-American Court of Human Rights, which is probably the most progressive in this respect. The nature of reparations that can redress the actual harm from a human rights violation shouldn't be so easily canalized the way it currently is under some forms of redress in human rights litigation. The Hague Rules in Business and Human Rights Arbitration extricates arbitral tribunals from the old categories and allows them to take further measures, recommend further measures that could assist in resolving the underlying dispute. This is significant opportunities for human rights claimants. So let me end in my last three slides on some points of comparison that I think are most relevant for the consideration of those who are watching today's webinar. Points of comparison between the Hague Rules and domestic or transnational human rights litigation and individual or UN human rights treaty bodies. First is on the applicable law. What was also quite remarkable was that the Hague Rules recognize that the parties will stipulate what the applicable law is, but if they do not, then the arbitral tribunal applies the law or rules of law, quote, which it determines to be appropriate. This opening can accommodate the entirety of international human rights law, environmental law, applicable business and human rights standards, even possibly the Business and Human Rights Treaty, if it is ever concluded and ratified, as well as instruments that have also become usages of trade, such as possibly softer standards, ESF, or environmental social framework standards that are applicable, or UN Global Compact standards, or even the New York Declaration or the Global Compact for Migration. Those softer instruments, should they be proven to be instruments that have become usages of trade. This is quite in contrast with other forms that have not been as flexible when it comes to the scope of applicable law in given disputes. So one example that I would take a look at is the Human Rights Committee's recent decision on climate change involving Kiribati refugees. In that respect, while the committee hewed very closely to the International Covenant on Civil and Political Rights, and to a certain extent dealt with refugee law, they did not touch the Global Compact. They did not look at the climate change agreement. They did not look at all other sources that came to bear on the allegations of violations that were being asserted by the Kiribati petitioners before the Human Rights Committee. That will not be a problem for an arbitral tribunal under the Hague Rules. The second is the flexibility, the adaptability, and the responsiveness of proceedings, and as I said earlier, available reparative measures. There are inherent limitations within domestic laws, within the jurisdictional competencies, for example, of international courts, such as the International Court of Justice, or regional human rights courts, such as the Inter-American Court of Human Rights or the European Court of Human Rights. There are also limited mandates under the UN treaty body procedures, whether they be the optional protocol in the Economic, Social, Cultural Rights Treaty, or the optional protocol on the Convention Against Torture, among others. Those same limitations will not be confining a Hague Rules arbitral tribunal. There will be different limitations, of course, and that adheres to arbitration in general. But those limitations that currently we have to deal with in other forms of human rights litigation and human rights procedures will not be present under these sets of rules. Most importantly, where we have struggled in human rights litigation, as well as in human rights treaty procedures, transnational litigation, domestic litigation, to try to involve third persons and experts in the fact-finding process, the Hague Rules Business and Human Rights Arbitration actually purposively makes it open for third-person submissions and experts, as I said earlier, which could potentially widen and illuminate the nature of a human rights violation and the appreciation of the kind of reparation that is necessary to address the human rights violation. So in this respect, arbitration contains that flexibility that the other forms of dispute settlement do not have. And lastly, which I can probably spend more time on Q&A, an arbitral award, contrary to, say, a UN human rights treaty view or procedure from a communications procedure, contrary to that, which comes up with a set of recommendations that is addressed to states, an arbitral award, as we know, will have binding legal effect and enforceability across different jurisdictions. This is particularly important for human rights victims, especially when there are sensitivities in the home court or say in the home state of human rights victims and challenges with respect to enforcement. I mean, one example I can give here is with respect to Filipino fishermen in the search in situations of distress in the South China Sea last year. Their own government refused to espouse their claim and refused to assist with respect to the private actor as well as the state actor that was involved. A private arbitral process could be of assistance because there's also no statute of limitations on enforcement. You would consider the rules, the secondary rules and secondary fora for enforcement. The arbitral award is final and unappealable unless the award is vacated according to the New York Convention. There is no home court advantage for any one party. it can, to a certain extent, enable the resumption of relationships between disputing parties that have a continuing relationship, such as, say, the shipping sector with the labor union, for example. And to the extent that this extricates, the Hague Rules can extricate human rights victims from the limitations of jurisdictionally specific resources and strengths for enforcement for prevailing parties, there is some hope that at least an arbitral procedure can give direct redress to human rights victims in a manner that none of these other forms of current forms of human rights redress are currently unable to do. I'll be happy to take questions on the New York Convention later, but for now, that concludes my presentation. Thank you.
Many thanks, Professor Desierto, for that extremely helpful analysis of the limitations of existing redress options and the key differences with the Hague Rules. Before introducing the next presentation, just a note to say that we are receiving all of your questions and we'll get through as many as we can at the conclusion of the final presentation. Our fourth and final speaker today for panel 1 brings an entirely new perspective to the table. Eric Dewiki currently serves as the President and CEO of the Commonwealth of Dominica International Maritime Registry, a full-service international ship registry. He is also the President and CEO of Northeast Maritime Institute and the lead delegate on government delegations to the United Nations International Maritime Organization. Eric has previously served in both the US Coast Guard Reserve and the US Merchant Marine. He has advised shipping companies, government agencies, and industry associations on regulatory trends and compliance programs. As President of the Dominica Maritime Registry, Eric is responsible for overseeing the implementation of international regulatory and legal instruments as they apply to each vessel, its owners and operators, and of course as well as to its crew. Eric, thank you very much for being here today to talk to us about these issues from the perspective of a flag state. Over to you.
Thank you, Elise. It's really a pleasure being here today, and I'm going to take a little bit of a different approach, a less technical approach to the delivery of what we want to talk about here today. Essentially, we looked at 4 areas of discussion points, and the first is the need for the flag administration to take human rights in addition to labor rights under the MLC 2006 more seriously in the day-to-day activities to protect the mariners and their dependents. The second issue we'll talk about is the opportunity to embed such an arbitration concept in new maritime legislation to set the tone and as an act of legal leadership. The third is greater transparency in the disclosure of the handling claims of abuse by seafarers by flag states, using in fact our program that we've dealt with for the Gulf Sky as a good example. And finally, supporting the principle that human rights apply at sea as they do on land. The bottom line is I started off my career as a seafarer, as a mariner in the Coast Guard. And then at a very young age, I transitioned into the Merchant Marine and spent 6.5 years of my life at sea on tankers and really understand the principles of what it means to be a seafarer and how that applies to both the rules and regulations side, but in fact, the rights of a seafarer and mariner. Oftentimes we are left to fend for ourselves and it is hard. Now in the position of the flag state administrator, I really have to take this very seriously. In fact, Dominica is one of the few, if only, open international ship registries that's not listed on the ITF flag of convenience rolls. And I'm very proud of that. The fact is the administration does take human rights very seriously. And MLC has taken a stand to enable us to start to foster and promulgate rules. In fact, Dominica is getting ready to ratify a whole series of rules and actually retend a national legislation that will include a very bulky promulgation of seafarer rights. And I think one of the things that we want to do is we want to look at human rights at sea. And we will certainly invite anybody to participate in the development of cogent laws and regulations as we strategize to implement a new national maritime act. I personally believe that we have the responsibility to take on the oversight to make sure that seafarers are protected. What good companies understand, what good shipping companies understand, is that compliance means money. And we're all in the business of making sure that we facilitate commerce. It was the very first thing I learned in my Coast Guard career at the age of 17. The Coast Guard's responsibility was to facilitate commerce. Ironically, I joined the Coast Guard to, in fact, engage in life-saving. And part of that protocol was making sure that life-saving saved commerce, so in fact we could go ahead and put food on people's tables. It's really important that we do that, but we need to do that in a responsible and an ethical way that probably hasn't been done before. Dominica, in fact, has a pretty solid reputation of supporting seafarer rights. Anytime we have a seafarer complaint, this administration immediately contacts the company and we go ahead and find out what the problem is. And in fact, we have a tendency to resolve it relatively quickly. So it is pretty exciting that we get the chance to talk about this in this symposium in a very strong way. The second issue is to embed such an arbitration concept in new maritime legislation to set the tone and as an act of legal leadership. The whole goal for myself is to make sure in this next transition in the Maritime Act that we are going to develop is created to include this arbitration component. So when Human Rights at Sea contacted us and started talking about some of the problems that they are realizing, we actually informed them that we are engaging in the development of a new national legislative tool. The idea that arbitration is coming up, we will go ahead and commit to all of you that Dominica will make sure that arbitration becomes a component and a tool for resolution of seafarer rights. I think it's a great idea. I think it's absolutely important as to how we are going to go ahead and facilitate human rights at sea. And I think it's very, very important that we do so in a way that is transparent and cogent. And I think the arbitration mechanism enables that while taking away some of the political influences that might steal from the opportunity to resolve a mariner's or a seafarer's rights at sea. The third issue is greater transparency in the disclosure of handling claims. I will tell you this much: as an administration, we take these claims very seriously. In fact, when we have claims, we were contacted by the folks at the Human Rights at Sea organization about a vessel called the Gulf Sky. And the Gulf Sky personnel had submitted a complaint to them, which they in fact referred to us, and we immediately started to look into the problem. The idea that we had not known about this suggests that there is a major problem, and we need more outlets and we need more transparency as an administration to enable mariners to file complaints. We have contacted the owners, we have contacted the operators, we have contacted the coastal state and the port state to engage in dialogue to resolve this issue, making sure that these seafarers are paid, making sure there's a mechanism for repatriation, and making sure there's a mechanism right now under COVID-19 that they are healthy. It is a tough situation. We went ahead and we detained the vessel. We issued a prohibition to sail immediately as soon as we found this out. And what happens when you issue a prohibition to sail, everything stops. So what we have to make sure is there's appropriate amounts of food on board, there's appropriate amounts of medical care being delivered, and there's appropriate amount of communication to and from our office, the seafarers' homes. They have the ability to communicate at home, making sure there's Wi-Fi capability. And we really did an outstanding job, and to the point where we're starting to see resolution and wages paid. And I think within about 2 or 3 weeks, we will have complete resolution. We can do that as an administration by putting some very stringent law enforcement tactics and practices on these vessels. It was said earlier in the beginning of this presentation that there is no enforcement by flag states. I'm going to tell you that's flat wrong. We have the ability to enforce, to work with other administrations, both flag states, coastal states, in port states, to engage in law enforcement practices. And in fact, we even have the capacity to apprehend a vessel at sea by creating bilateral agreements with such, in our case, with the United States. We've worked very, very closely with the United States Navy in the past, the United States Coast Guard, the United States State Department, and in fact, the United States Department of Treasury in the Office of Foreign Asset Control. We have had a great relationship with these folks. In fact, making sure that law enforcement capacity can be promulgated and promoted and realized by a small flag state. It just takes effort, it takes resolve, and it takes knowledge as to how you can do this. It's unacceptable for a flag state to ignore their responsibilities. We, in fact, are known as the flag of responsibility. When I was approached originally to develop the Commonwealth of Dominica International Ship Registry, I said no. Being a merchant mariner, being the son of a merchant mariner, being the grandson of a merchant mariner, I thought it was ridiculous. In fact, the Commandant of the Coast Guard at the time called me and he said, listen, the system doesn't go away. It's never going to go away. I want you to create something that is reliable and viable, and in fact, used as almost a think tank to demonstrate best practices. Now, we've had successes and we've had a few failures as well, but the failures have taught us how to fill the gaps. But I can tell you this much, at the end of the day, we have to take responsibility to facilitate action against these bad actors. Now, there's only a small group of bad actors out there. Most ship owners and operators are doing the right things, but this is a new mechanism that can promote even better compliance. And I think we fully support the idea of arbitration, and we want to engage in it. I think the last in the fourth concept here is supporting the idea that human rights apply at sea as they do on land. I've spent my life traveling around the world, 85 countries later, and almost every place I've been to has been as a result of some type of violation. And the idea that we have the capability of developing something new and cogent and realistic is an opportunity that doesn't come often. And that's the blessing of the Commonwealth of Dominica right now, because it is in fact managed by Northeast Maritime Institute in the College of Maritime Science. We have the ability to do studies. We have the ability to implement quickly without much regulatory haste. And we have the ability to partner with folks without any bureaucracy, really. If it's right, we're going to do it. And if it's right, we're going to engage in a responsible way. So we open up the floor to great dialogue. I've just listened to great presentations. Diane, you blew me away with your presentation. And we really want to engage, and we would like to challenge this group of people and the selected people to create a working group to develop a national strategy for the Commonwealth of Dominica to implement this protocol in its next iteration of its National Maritime Act, which we will submit to Parliament by 2021, by January of 2021. Thank you, and I truly am grateful to be allowed to participate and learn. Thank you so much.
Thank you very much, Eric. That concludes the fourth and final presentation for panel one. There is a lot to digest and unpack, and unfortunately, not very much time at all remaining. By my watch, we've actually used our full hour, although perhaps we can afford to run a little over. And as I mentioned earlier, there will be another opportunity at the end of panel two to continue the general discussion. So if I could ask all participants from panel one to turn on their sound and video for the Q&A session. I think I'll begin with a question from the audience. We've had quite a number. Hopefully some of them have been addressed in the course of the individual presentations. But I'll start with this one from Ivan Axel Dubrava, a student of international arbitration, who asks, does the need for such a specialist project as the one that we are discussing today prove a certain failure or the weaknesses of other more general projects, such as the Hague Rules? How can these different projects coexist and perhaps even support each other? So Professor Desierto or Martin, perhaps you might like to comment here.
Sure, I think I can answer that in general by saying that the Hague Rules are the start of the journey. They're not the end. They're meant to be a template that already is had a lot of thought going into it in order to bring it within the human rights space, but is open to being further elaborated, further tailored to specific contexts. And the fact that I think you already are seeing within this event some collaboration between those who are involved in the Hague Rules and human rights at sea bodes well for complementarity rather than undermining each other's initiatives.
Absolutely, and perhaps on a related note, Professor Petrig, in your presentation, you discussed the many different scenarios in which a human rights at sea claim might arise. And Martin and Professor Desierto, you both discussed flexibility being one of the key advantages of the Hague Rules. Do you think it is possible for one set of rules to cover all of these potential scenarios? Or is it the case that, as Professor Petrig suggested, different rules for different constellations may be needed?
If I may, I actually do think that the reason why the Hague Rules are also so adaptable is because the model clauses themselves give the flexibility to the parties to shape the procedure. So as I said earlier in my presentation, if the arbitral tribunal determines that it's appropriate according to the circumstances of a case or a dispute, whether it is a B2B or a business to business or an individual to business setting, or even a constellation of different actors in the maritime space, that could very well be designed by the parties themselves. I won't preempt the second panel who will excellently discuss consent, but that is the possibility. Martin talked about the Bangladesh Accord. That was unique. You had the International Labor Organization, the government of Bangladesh, the labor unions, as well as the private sector, all in the very same dispute, all involved as stakeholders. So especially for the uniqueness of what Professor Petrig was talking about in the maritime space, the Hague Rules will be flexible enough for parties to consent to that adaptation.
There's certainly a lot more that we can say. I am conscious that we're out of time. So perhaps we'll pick up this discussion again at the end of panel two.